Hey, all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning. Welcome to the Appeals Court. I am Justice Meade. With me today on the panel are Justices Sachs and Woods will be the panel for all of the cases we're going to hear today. Each side gets 15 minutes. You needn't use all your time. We do not entertain rebuttal. We have read everything. My best advice is to get right to the point. With that, I'll call our first case now, 25P 983 BRAMMER BIO Mass versus 290 BINNEY LLC. Mr. Scharf.
Good morning, Your Honors. May it please the Court, and thank you. It's a pleasure to appear before you. Thank you for admitting me pro hac vice. When we appeared before the Superior Court, we told them that the harm was real and significant, and that it wasn't only the construction that was ongoing that was going to cause the harm, but that the building that was coming out was going to be materially affecting our ability to be able to operate as a specialty pharmaceutical manufacturing company performing life-saving work to save people. The building and their plans would seriously encroach on our leasehold property. Now, all of that has come to fruition. We are out of business in that building with years and tens of millions of dollars left in our lease obligation, and we can't even relet the facility. We have moved...
Can I ask a question about the renewal of the lease? I read it a few days ago. The date of the 5-year extension of the lease, what I'm really trying to zero in on so you can help me, is when you signed that, what was the state of the building of the skyscraper next door?
At the time we contended we had the right, we went to court.
Yep, I remember that.
We won, yep. And at the time we exercised that lease, we were not aware that they were coming out in the way that they were, meaning anything that was being done from a construction perspective. Okay. We were negotiating with them. We were having weekly meetings. We were expressing concern. And in fact, as the record shows, they came to us and asked us for permission to subdivide the property through a real estate grant that we would consent to, so that the parcel of land that they've arrogated for themselves, and which includes the building, the commercial office building that's gone up, was something that they were interested in having. And they said, can we have your consent? Can we have your landlord's consent, since we're the subtenant? And we said no. And it wasn't like we didn't express why we said no. We talked about the very concerns that we were having on the impacts of the entire construction that was going on in the area that was detrimentally affecting matters. And we moved expeditiously. I mean, the second we saw that slurry wall coming out and open and realizing that they were encroaching with an intended permanent structure, we moved to the court. Now, the court said...
So at that moment, you had already secured, through help of the court, the 5-year extension of the lease, is that right?
Yes, and it has a second potential option for another 5 years on top of that. Yes, Your Honor.
Thank you.
And when we were denied relief, we went to a single justice expeditiously, and they referred it to the panel. And we're here now because that's how long it took us to get here. The Superior Court's errors relate to the interpretation of the master lease, the 1990 easement, and the concurrent 1990 consent, as well as how the Superior Court interpreted the 2024 restatement of that easement. And these are questions of law, Your Honors, that are subject to a plenary review, as is the Superior Court's determination that the 5-foot multi-story taking of Brammer's leasehold is somehow not a trespass because we didn't have complete control and exclusive control over it, although we had rights over the very property. It was part of our lease. It was part of the demised property. Now,
when you get to the legal issues about the judge's decision, can you be sure to address the language in the 1990 easement that says the nature and duration of the easements, unless sooner terminated or modified, shall be perpetual? And
Yes,
it seems to me that the nature of the easement, it used to be a vehicular access, or at least part of it was a vehicular access easement. Now the nature of it has changed to an easement to allow a building.
Exactly, Justice Sachs. And I would start with first, what did our predecessor in interest consent to that Boston Properties is trying to impose upon us? And that's at RA 3rd 421. And it says, we consent to the execution of further documentation to any easement rights heretofore or hereinafter granted by the trust, keywords, pursuant to the terms and conditions of the easement agreement. So that directly leads us to what is that easement agreement? And when we look at that easement agreement closely, I think there are some significant things that we need to talk about. We need to talk about the fourth page of that easement, where it says this is all being set up, and it's at paragraph F on page 4, in order to provide certain services, amenities, and benefits to the fee owners from time to time of Tract 1, 2, CRA, 11 CT, and are willing to grant certain easements across various of the properties. And then we turn to the next page, and it says the easements granted herein are shown on the easement plan. And then it talks through that there are several easements being granted, and they are all utilities: gas, telephone, sanitary sewer, stormwater, water services, electrical service, street light, vehicular access and egress, pedestrian egress and access. And importantly, the paragraph that follows that says, notwithstanding the easements herein are granted, they are for the benefit of the parties, and the benefit is limited to the right in common with others entitled thereto, and to connect to and have their respective individual development parcels and the buildings and improvements from time to time located thereon.
Where are you reading from?
From page 6 of the...
Page 6, okay.
Page 6, paragraph 4, right in the middle, served by the various utilities from time to time occupying the various easement parcels and for use in common with others entitled thereto, the pedestrian and vehicular easements provided. And then you look after page, there is a recitation of the benefited parcel. So there is an intended benefit, and each one is utility, and every one is supposed to be benefiting to that. Fast forward ahead.
250 is one of the properties benefited, is that right?
That is correct. That is correct. And then when one goes and looks at the 2024 easement, first and foremost, they make it very clear on RA Volume 1, 578, that for the avoidance of doubt, this is a superseding the 1990 amendment. Now, I know we don't just look at titles to documents and recitations, and we look at the quality of the document. But when one looks at the quality of the document, and one focuses in particular on page RA Roman numeral 1, 583, the 290 Binney building easement, and that's on page 8 and page 9, it talks about that they're going to be constructing and giving to 290 Binney an exclusive and perpetual right and easement to construct, reconstruct, support all portions of a brand new building, including below grade and above grade. What they did here was not amend an old utility easement to make it appropriate, have modernity for the current period of time.
Change the nature of it.
It's just a brand new grant of an easement that has nothing to do. And
Well, it's in the area of the vehicular access agreement, right? It doesn't go outside the bounds of that?
That's-
And it's between parties to the original easement agreement,
Yes.
each of whom is entitled to be benefited?
However, yes, but we do not benefit from that commercial structure. We have no benefit from that. It's entirely a detriment. They don't even try in the 2024 amendment to, tell you that somehow it's benefiting our client's parcel.
Any easement that is going to benefit one party may be a detriment to the adjoining party, the servient estate.
Yes, however, all of that needs to be taken in context of their grant of right, which they basically signed an agreement amongst themselves, right? You look at the signature pages to 2024, you only get Biogen, who was our tenant, but Biogen is also their tenant and going to be benefiting from the 290 Binney. So they are all benefiting from it. We are having it imposed with absolutely no benefit. And the evidence that was put in before the Superior Court described each and every detriment that we were going to have. Our turn radius for our trucks, our ability for our pedestrians to go. And that was not just temporary, because the building that is up there and their parking structure and going up into their property and our loading dock, the only evidence that was put before the Superior Court showed that the common use was incongruous. They couldn't happen at the same time. And therefore, it violated the precepts that if there was going to be an easement and a grant that was going to be detrimental, it required a concurrent benefit that benefited us. We received no benefit, and that is consistent with the law that talks about what is a trespass. Trespass can happen even when people have common usage, and as a consequence—
If the easement is valid, then there's no trespass. Would you agree with that?
I would agree that if the easement is valid, or more importantly, the consent to the easement may be valid among the parties, but they have to rely upon the consent that has the special language that our predecessors agreed that it would be pursuant to the terms and conditions of the 1990 easement. And we don't have that here. And one of the most important overriding principles is actually found in the master lease. And the master lease has two provisions, and this goes to error that the Superior Court made in interpreting these agreements. First of all, Section 16.4, which is on page 54 of the prime lease, says that we have a right to peaceably hold and enjoy the demised premises during the term of this lease without interruption or disturbance during the term of the lease. But then there's another provision, 7.2, which talks about future development. Now, it talks about development of roadways, and maybe we don't have the strict adherence to the title, because the lease says, the title's there not, for any other purpose than to give you a sense of what it's about. But 7.2 talks about roadways within Parcel 2 and the development area. But there is limiting language that says that whatever you want to do as it relates to roadways, sidewalks, and pedestrian walks, you can do that provided such use does not unreasonably affect tenants' use of the site.
But both those clauses, 16.4, is it, and 7.2, were—
That's 7.2, yeah.
—superseded by the 1990 amendment and the consent and subordination, weren't they? So doesn't it all come down to the 1990 amendment? Sorry, the 1990 easement agreement?
So, yes, but the 1990 easement agreement and 7.2 are harmonious, and they can be harmonized because the 1990 agreement and the consent is entirely consistent with what they were doing in 7.2. And that makes my point all the more. The point being that 7.2 doesn't talk about constructing a building that benefits only the other parcel. The language it uses are talking about roadway, sidewalks, and pedestrian. And even then, it can't unreasonably affect our tenants' rights. It has
Stop you there for a second. A simple question. Unreasonably affect, I took from you the single clearest burden you could articulate was the loading dock, impact on the loading dock. And I think you just said it's incongruous, that I think what you were saying is it's impossible for two different, the skyscraper and your client to use their loading docks at the same time. I think that's what you meant.
to go into their parking lot and for us to have an appropriate
Right.
turn
But
radius.
the judge at page 10 of his decision, I think it's a him, says, it will be possible for trucks to use the loading docks at the two adjacent buildings at the same time. So I think you're saying, are you saying that's clearly erroneous?
Yes.
Okay, thank you.
Because there was no contrary evidence. The evidence that was put in related to this. I appreciate I have 13 seconds remaining, and as for the rest of our arguments, I rest on our brief unless the panel has any other further questions.
Seeing none, thank you.
Thank you.
Mr. Fantozzi, they're all here. Thanks, AJ.
Good morning, Your Honors. May it please the Court, Martin Fantozzi for the defendant appellees, Boston Properties Limited Partnership, 290 Owner LLC, the trustees of 14 Cambridge Center Trust, and Turner Construction Company. As we have submitted in our brief, this appeal should be dismissed for three principal reasons. First, in the intervening 2 years since this matter was considered by the Superior Court, there have been two critical changes in circumstances, which we've documented in the supplemental affidavit of Jeffrey Lowenberg. Those two changes in circumstances are, one, a year ago, BRAMMER shut down its operations at the site. And second, the building is now complete. The building is built. The construction that they were seeking to enjoin is substantially completed.
But they're still paying rent, though, right?
Yes.
And
This isn't
they still have
the permanent.
Excuse me. They have the right to sublet it as well, right?
They have the right to sublet, but as you heard counsel tell you, their position in the trial court below is that they can't sublease, and
Because there's a skyscraper on part of the property.
yes, and they're seeking millions of dollars for that. But the question is, the construction that they were seeking to enjoin 2 years ago is no longer ongoing. This was an application for a temporary injunction, not a permanent injunction, to bring to a halt construction that was then supposedly substantially interfering with their operations. Those operations are no longer happening. That construction is no longer happening. That's the first point. The second point is that when they signed their sublease, there was a consent that all three of these very sophisticated public companies signed. And that consent to their sublease, they acknowledged their sublease rights were legally subordinate to all documents of record, not only now, but hereafter. That's in their consent to sublease. And whether they knew it or not, they should have known that one of those documents was the 1990 consent in subordination that their predecessor, Biogen, signed 35 years ago.
So this isn't a mootness argument. This is the merits you're getting to.
Yeah, now this is the second point. The second point is that their easement rights, their rights to this portion of the property that is within the boundary of the premises have always been subject and subordinate not only to the master easement, but also to any amendments thereto and any easements created thereunder.
So I have a foundational question which I can't get through my head. An easement to me seems like, I mean, a utility easement, but the nature of it, the essence of it is property that both parties can share. This seems like admittedly only 5 feet of worth of a taking. I know nobody uses the word taking, but they use trespass. But it seems to me it's fundamentally different if you plonk a skyscraper down on 5 feet of their property. Maybe there's a de minimis problem, but I get it. They can still use their loading dock, but it's not an easement anymore. It's a taking. They can't possibly use it. So does the 1990 agreement go that far to say we can take that property?
I don't think it's a taking, and I think the commercial wharf is the right case to focus on, Judge Wood, in that issue. So in commercial wharf, which is admittedly a condominium statute, but it's a very significant SJC decision. And in that case, a condominium was formed at commercial wharf in Boston over a pre-existing parking easement. And what the SJC held in commercial wharf is that there's nothing inconsistent in the law of real estate with contemporaneous possessory rights in real estate, i.e. under a lease, and pre-existing non-ownership rights in an easement. And what the court in commercial wharf went on to hold is that because the easement pre-existed the formation of the condominium, it did not unlawfully divide the common areas because the easement never became part of the possessory estate. So too, as in this case, the pre-existing easement never became part of their possessory estate. There is no taking because it wasn't there, and the subordination agreement that Biogen signed, not only the easement as it may exist, but also the easement as it may be amended. And the easement specifically permits easements, as Judge Sachs pointed out, that alter the nature of the existing easements, and it only requires the consent of the fee owners and the consent of mortgagees, not the consent of subtenants, not the consent of tenants. And
it seems like what Judge Wood is asking is, okay, maybe you can do anything you want if it's an easement. You can change the nature of it. But is this an easement? Is this the conveyance, almost of a fee interest in that 5 feet above ground and the 8 feet below ground? Because the subtenant can no longer do anything there.
But the subtenant's use of that area was essentially no different before the easement or after the easement. It's
actual use, correct, but it's the use that it was permitted under the lease, which is now saying is diminishing the value of its ability to sublease, is not the same. I mean, previously, they could, I don't know what the zoning restrictions are there, but maybe they could set up a hot dog stand there as long as it didn't interfere with the other easement that other properties had for vehicular access.
But
now they can't because there's a building there.
With all due respect, they had no meaningful use of that property, and that is actually one of the things that the trial court said.
Sorry, when you say that property, I think you mean the 5 feet?
Yes.
Okay.
I mean, we're talking about, first of all, 2 easements. A subterranean slurry wall, which cannot possibly impact their limited use of what was a service drive. The only purpose, the only use they had of this area was to get access to their loading dock. That's it. And I just heard my brother say that he's challenging as clearly erroneous the finding, the Superior Court's finding, that there was no material adverse impact. That is not in their brief. That is not an argument that they've made. You will nowhere find.
But I don't know that we're focused, at least I'm not focused so much on actual use and whether there was a material impact on the actual use that 250 that Brammer was making, but more the question of is the interest granted an easement. So, I mean, forget 5 feet. Let's say it's 100 feet. Let's say that the agreement, the 2024 agreement said now the 290 can build a building on the first 100 feet or 150 feet of the neighboring property. Is that an easement? It might be, I
Perhaps
just don't know
not,
the
perhaps,
lines.
but it is clear that there are easements for encroachment. That is not an uncommon phenomenon in real estate law. Calling every,
Just to amass case about that?
I cannot, but I'm certain if you would give me permission, I could submit a case. There's no question that people use, and in fact, I can give you a better example. In the Fourth Amendment to the master lease, there was an amendment to the easement to deal with an encroachment. And
It wasn't clear to me from looking at that whether that was quite like this. If you
Well,
could
there wa-
point to the language, that would be useful.
there was also an easement for a new connector building, a completely new building in the Fourth Amendment, recorded in 2011, 14 years before, this controversy. So I do think there's no doubt that you can have an easement for an encroaching building or a slurry wall. And at the end of the day, these sophisticated parties agreed that the only limitation on the power is that we can't do something that substantially interferes with their use of the property and their use of the road. And that's the only limitation that you'll find in Section 7.2 of the master lease. That's the only limitation that you'll find in Section 16.4, the covenant, which is essentially the contractual covenant of quiet enjoyment. And their argument fails because of the finding of the Superior Court that there was no material interference. So that limitation, which does exist under the master lease and hasn't been abrogated by the consent, hasn't been violated. And I would add that none of this was discussed before the Superior Court. They didn't even bother to submit the consent and subordination to the Superior Court. This only came up in response in a short colloquy at the argument when the court specifically asked Mr. Scharf to address this issue. So whether or not this issue has been preserved, it's quite clear that these parties agreed that we had the right to amend the nature of those easements, and so long as we did not materially interfere with their use of the property, they have no claim. And there is no such interference. And the fact that there's this claim that these are new easements, but the consent specifically says easements heretofore granted pursuant to the master easement, which necessarily means that you can grant new and different easements, which is consistent with the language of the master easement itself that permits the alteration of existing easements. So at the end of the day, the Superior Court did not err by concluding as a matter of law that the master easement was lawfully amended. As a result, Brammer's rights under its sublease are legally subordinate. And finally, that there is no material adverse impact on their limited use of this service drive. And for all of those reasons, there was no error and the case should be dismissed. And with that, unless Your Honors...
But so this is an appeal of the denial of a preliminary injunction, right?
That's correct.
And so regardless of what happens here, the underlying merits case is going to continue to go forward?
That is correct.
Right. And so theoretically, and it's obviously not before us, but there will be litigation about the extent to which the building of this skyscraper damaged their business. That is still to be resolved by the court on a different non-preliminary injunction standard, right?
Yes, we are engaged in expert discovery on their claim for hundreds of millions of dollars in the Superior Court.
I got it. I just want to make sure I was right. Right.
And they haven't withdrawn their claim for a permanent injunction.
Yeah.
But the question here is whether we're entitled to provisional temporary relief. That's the only question from a harm which is no longer extant.
Right.
Which is why we say this appeal is moot, and you can look at the Riley case and the Andover cases. And in the Andover case, this court opined that in that case, the the appellant did not act expeditiously to present its arguments to the appeals court. While they were invited by the single justice to expedite this appeal, they did not. They did not seek to expedite the assembly of the record below. So in effect, the construction that they were seeking to enjoin has now been completed, and there is no basis to issue an injunction at this point. And it is for another day whether or not they're entitled to any permanent injunctive relief or any damages, but that's not before your honors. Without any further questions, I'll rest.
Seeing none, thank you. Thank you both. We'll return to the first two cases on our list, 25P488 and 25P487, AT versus AQ and MC versus AQ. Mr. Spinelli.
Thank you. Good morning, Justices. May it please the Court, my name is Jared Spinelli from Rubin and Rudman, and I represent the appellant AQ for purposes of this consolidated appeal. You probably already realize that the reason why there are two docket numbers is there were two corresponding restraining orders underlying at the Newton District Court, one for the plaintiff, the former wife or mother, and the other on behalf of their adult incapacitated child, AT. I know and I appreciate that you've already read the brief, but just because it's impactful to my argument, I will stay with just the salient, most important facts, which are that the parties were briefly married in the early 1980s, and this is a theme about we're talking about things from 40 years ago. They had one child, AT, and they were divorced in the mid-1980s when the child was a toddler. There was a custody battle in New York where they resided. It resulted in an investigation by the New York equivalent of DCF, as we would understand it here in Massachusetts. And during the pendency of the divorce litigation, the mother made sexual abuse allegations against my client, AQ, involving the child. That was and it's all on the record, that was investigated by multiple neutral third-party professionals, and that was ultimately debunked, and there was no evidence to support mother's allegations. There is
Was that debunked, as you say?
Sorry, it was. I apologize, I would say, rather than debunked, perhaps I would say there was insufficient evidence to support the allegation.
And that conclusion arose in an adjudicatory proceeding?
Correct, Judge.
What was that?
It's in volume 3 of the.
What was the proceeding?
The proceeding was in the divorce action. He was never prosecuted.
There was no separate investigation of.
No, sir. It was essentially a custodial investigation akin to our custody or a GAL investigation here in Massachusetts.
And they were not credited in the divorce.
Correct.
Action.
And what's in volume 3 is the judge's conclusions, which found that ultimately there was no evidence that the neutrals, none of them found any evidence to support mother's or corroborate mother's accusations, and that, to the contrary, mother was found to be, the word was histrionic. The mother appealed. I should say in the divorce, it was concluded that it was what was best for the child, AT, was to have joint custody, see both parents. Mother appealed, and the New York Supreme Court denied that appeal. What did mother do? She took off to Spain, essentially, well, not essentially, kidnapping the child in 1987. She admits
Are you saying that the result in the divorce case should have collateral estoppel effect here?
It's an interesting question.
I don't see that in your brief.
No, where I'm coming with this is what ended up happening in the Newton District Court, 40 years later, Justice Sachs. She left to Spain, didn't tell anybody, stayed in Spain for 10 years. He had no idea where his son was, my client AQ. Did some investigation around 2000, 2001, found out that they were back. They were living in Brookline here in Massachusetts. wrote his son a note saying, I never abandoned you. The son was 21 by now. I never abandoned you. I've always loved you.
Sorry, we've read the briefs, but I'm trying to zone in on the relevant question, it seems to me, is whether, fast forward to today.
Yes.
And there's a hearing in front of a judge, and MC testifies, that 40 years ago, your client physically assaulted her. And that is, and it seems clear that, for whatever it's worth, this judge, knowing about that proceeding 40 years ago, said, I disagree. And said some more things, but broadly says, I credit the plaintiff, and having seen the plaintiff testify, I believe the plaintiff was assaulted, and I believe her fear of imminent harm is reasonable, and I'm granting this. So it seems that that's what we need to decide. Is that, with proper deference, is that wrong, and why is that wrong?
Thank you, Justice Wood. I agree with you. That is absolutely what the crux of today is, well, except for what I led with in my brief, which is they walked into the courtroom in Newton District Court, and the judge thought that she was there to be Madam Interpreter, a Spanish interpreter that morning, and said, good to see you again, and identified her as a colleague. She said, I assume that she was working, and she identified, this is the trial court justice, the lower court judge, I've worked with the plaintiff, probably every judge has, and she said, I have a professional relationship with this plaintiff. On the record, I have a professional
But so knowing all of that, there was no motion requesting the judge to recuse herself.
There was not. This is all unknown until it happened.
So how you say that we're reviewing this for a substantial risk of a miscarriage of justice, which is a criminal standard. Do you have a case that imports that into the civil 209A context?
What I know is that Article 29 of our Declaration of Rights, Justice Meade, requires that my client be afforded to have
it does.
an impartial justice.
And I understand what Article 29 says.
Yes.
But my question is there a case that allows us to review for a substantial risk of a miscarriage of justice a claim in a civil case that otherwise would be waived?
I don't have such a case at the top of mind, Justice Meade.
I couldn't find one.
Okay. Nevertheless, like if we set aside the issue of whether and to what extent there was inherent unfairness in the justice's impartiality, the evidence itself, I think, clearly fell short, and this is Justice Wood's ultimate question, is let's talk about this, fell short of the 209A standard, number one. Number two, some evidence was mishandled. There was, so let me talk about first the failure, in my opinion, to satisfy 209A. And I'll get to coercive control at the end. But the SJC case Rosado talks about that fear of imminent physical harm cannot be merely psychological distress, and that's also the Wooldridge versus Hickey case out of this court in 1995. But we need a preponderance of the evidence that there was either an actual physical harm or that she was in reasonable fear of imminent harm, and that reasonable fear has to be objectively looked at and sustained.
So can you address Callahan v. Callahan? Your opponent cites it. That's the one where the fellow is incarcerated, and he broadly argues, it can't be a reasonable fear if I'm incarcerated. And this court held that where she had in fact been assaulted, her fear, it's adequate, she satisfied the statute in a nutshell. Right. How is this different than
So
that?
AQ was never incarcerated. AQ has known since the early 2000s, Justice Wood, that they were residing in Brookline, never bothered them. Wrote a letter to his son. It is unchallenged that that AQ has never spoken with MC since 1987 when she left New York State, and he has never spoken with AT since the child was 5 in 1987 either. So it wasn't as if he didn't have an opportunity, which I believe is and that's the distinguishing point, Justice Wood, to your question, is he has known for over 20 years that they are here in Massachusetts and in Brookline, knew where they were living, and never bothered them.
Okay, and so another question. Sure. The thing that seems to have triggered this, maybe I'm speculating and I don't want to speculate, but your client files this petition, I don't want to mischaracterize it, to challenge his ex-wife's guardianship of the son. And it seems that that's what causes her anxiety and causes her to, I don't know if that's in the record, but causes her to file this 209A application. Is that sufficient for her? Why is that not sufficient for her to be concerned about him coming back into their lives and causing a reasonable basis to fear harm?
First of all, thank you I appreciate the question. First of all, you used the word anxiety, and I have no doubt she subjectively was anxious about all of this. I think that anxiety was objectively unreasonable, and that's the Wooldridge case that I was talking about, and the quote was that generalized apprehension, nervousness, feeling aggravated or hassled, i.e. psychological distress, when there is no threat of imminent serious physical harm, does not rise to the level of fear of imminent serious physical harm.
Because the judge was allowed to consider MC's affidavit, right?
Yes, and I think MC's... yes, Judge. I think that affidavit was
I haven't
really-
asked the question yet.
I apologize.
And she avers in the affidavit that she fears for her son's safety because AQ had said he'd rather see him dead than with her, and that one day she would look in the mirror and not recognize herself because he was going to cut her face to ribbons.
Mm-hmm. And I would suggest...
Does that not generate a reasonable fear of harm?
I think that's consistent with the former wife's histrionics, which is not...
That's a question of credibility, though, you'll agree, right?
I agree, and I think
the judge, the first question I asked was, could the judge credit that affidavit?
Yes, the judge could credit it, yes. But this is what we were coming back to. And Justice Wood, I never answered your question. There was a petition, he requested that a professional guardian be put in place. Wasn't otherwise looking to upset the apple cart in any other form or fashion. He wasn't looking to be the guardian, wasn't looking to do anything other than have a professional review of, is my son okay? By the way, the son's 44 at this point. And he was seeking a professional guardian. I think the filing of a pleading, it shouldn't be reasonably considered to be something that would be subject to imminent physical harm as defined and understood under 209A. That would be, to me, a completely unreasonable take.
Okay, so I understand that you wanted to answer Judge Wood's question, but now can you answer mine?
Yes, sir.
Why wasn't it reasonable of imminent fear of harm given the allegations in the affidavit?
Justice Meade, clarification is yours as it relates to harm to the child or as it relates to harm to the mother?
Both.
Okay. I think there is zero evidence in the trial record to support that the father ever harmed the child. And I'm talking about...
No, it's a threat.
Yep. It has never threatened to harm the child.
According to the affidavit, he has.
According to the affidavit, which not all affidavits are accurate, not all affidavits are truthful.
We'll go back to how I originally started. Was the judge entitled to credit the affidavit?
The judge has the ability to credit the affidavit. I find that the judge crediting the affidavit was an abuse of that discretion. That's my legal argument.
A credibility determination can constitute an abuse of discretion.
Yes, the plaintiff, MC, as you can see in the record, brought newspaper periodical articles from the 80s in support of her request. For a second before my time is up, coercive control. Her own lawyer asked MC, has AQ coercively controlled you? She said yes. Her own lawyer said, give the court an example. She said that when they were married, he took 2 phone books away from her. Again, 40 years ago in the 80s, that was the best example and the only example that MC offered to the court by her own direct examination.
Can I go back to Justice Meade's question? I can't remember the answer. The date that the plaintiff alleges that your client said that to her? I'm going to cut your face to ribbons and I'm going to kill you.
That could have only been in the early to mid-1980s because they haven't spoken since the divorce proceedings in New York.
Okay.
And again, my client denies all of this.
Right, no, I get it.
But it would have been 40 years ago. Okay. And so we know our case law says that a 209A has to be prospective. You can't get a restraining order for past actions, of course, unless it is found that it's a reasonable fear of future imminent physical.
Putting the judge's decision in the best light.
Yep.
The affidavit says, he said that he was not in a hurry, but that one day I would look in the mirror and not recognize myself because my face would have been cut up in ribbons. So he's saying, this is a long-term threat. In other words, you could interpret that. So if the judge credits that, then would that be a basis for reasonable fear of imminent serious fear?
Justice Sachs, this is,
Even though nothing's happened.
I
in 20
understand.
years.
I think what the trial judge had to have done was weigh that allegation against the rest of the record, and the rest of the record included the divorce judge from New York's 30-page,
Right.
which
But
said
we're-
she was not credible in the 80s, that said she was histrionic, that, that all the professionals, social workers, doctors, said she was
The judge
wrong.
gets to make her own credibility
Right.
determination, doesn't she?
She does, but when you have a 209A in the Newton District Court where you can say anything, right? And it's hearsay, no less, and there, as my brief has some, I'll rest on my,
Statement in the affidavit is an admission of a party opponent. It's not.
right, if it's true, Justice Sachs. And I think what I'm saying is it was an abuse to hear that allegation, which of course a trial judge has the opportunity to find credible, of course.
You do, and I'm going back to something Justice Sachs said at the beginning of the argument
Yes.
about collateral estoppel. You do argue in your brief on page 27 that it's res judicata, what was determined in New York.
I am, yes, I am.
You don't cite any authority for that, but you do say it.
I do say it, Judge, at 27. I am bothered by the fact that it was already investigated, and it was already, and my client was exonerated, for lack of a better word.
And was that brought to Judge Quealy's attention?
It was. It was. And again, I think all of this comes down to the fact that they were co-workers at the district court. She thought she was there as a professional. She announced that she had a professional relationship and didn't recuse herself. And I think that absolutely had a resounding material effect on the rest of her analysis and her discretion, which was abused. I rest on my brief. Otherwise, I see my time is up. I appreciate the questions this morning, Justices. Thank you very much.
Ms. Sofio.
Good morning, Honorable Justices of the Appeals Court. Jessica Sophia on behalf of MC, individually and his next friends to AT. So I would concur with much of the questions that your honors have been asking. The idea that, first of all, the issue with the recusal wasn't even raised on the record, so therefore it's dead in the water, it's invalid. I think it's just, this brief was extremely long and there was a lot of side quests and things that made it take longer and be more expensive. And considering the fact that coercive control was found, it's not insignificant that such a significant amount of legal work was put on MC and AT.
Sorry,
Did the judge base the issuance of the extension on imminent fear of harm or on coercive conduct, the new?
It was primarily imminent fear, but she indicated there was some coercive control.
What was that?
So at the same time that the restraining order happened and the appeal was in progress, the appellant had filed an action in probate court to remove MC as guardian. So they were in a protracted, contentious litigation over the care and the treatment plan of the son.
But he had a right to do that, didn't he?
Sure.
Yeah. So it's not like a slap suit or anything like that, right?
No, I mean, I think under the totality of the circumstances, Your Honor, there was,
But utilizing the judicial system to achieve an end in favor of himself, how is that coercive?
I think when combined with some of the incidents that were testified to on the record by MC, including, sending a stranger to the door with a letter
When was
AT.
that was
In the early 2000s.
when
I mean,
the
everything is.
child was 2?
No, I think
Oh, no, he was an
a little
adult.
older. This is when they were in Massachusetts
Okay.
after they had returned. And, she had also testified to during their relationships and financial abuse, but.
And this is the letter that AQ was trying to communicate to the child that he's always loved him and did not
Yes,
abandon
yes.
him.
And
How is that coercive?
Just the manner in which it occurred. There were also some incidents at the doctor's office demanding access to records. And I mean, I appreciate what you're saying, Your Honor. There certainly
No,
is.
I'm just trying to figure it out. And we're going
I think
to
that
ask you about the
combined-
phone books in a second because I don't understand that at all.
I think, well, yeah, I mean, the phone books might not be the best glaring
Were you
example.
literally
but
talking about the yellow pages or?
She had indicated on the record when she was testifying to some of these incidents during their relationship, which would include control. So in that sense, that's cutting her off from contact, right? That was sort of why that mattered, because normally a phone book is not a big
Paper
deal.
lists of telephone numbers.
Excuse me, Your Honor?
Her paper books containing
Yes.
telephone numbers, which we used to have.
Yes,
Oh, like
exactly.
her contact list is
Address book.
which would be valuable in the 80s and not so much now.
I would agree, Your Honor. And I do think that, my brother as well, there is a lot of occurrences that happened a long time ago. And now we're looking at today, we're looking at the totality of the circumstances. We're looking at the both objective and subjective elements here to determine whether or not there is, a reasonable fear of abuse under the circumstances, Your Honor. And so,
Do you agree that there's nothing in at least the last 20, maybe 30 years that her imminent fear of harm is based on?
so according,
Other than the guardianship action or?
well, it's, are we talking, Your Honor, coercive control or just in general, the
In general.
imminent fear? So, I mean, it's not for me to say, Your Honor,
No, I'm asking you what the evidence was before the judge who made the decision.
So the evidence was based off of prior experiences in detailing significant abuse, significant sexual abuse, and
Now, your brother says that all of that was adjudicated in AQ's favor and it can't be considered.
well, I think it's interesting that the judge used the word histrionic, Your Honor, because this was a different time. There was also evidence on the record that demonstrates that there were multiple professionals that came out, were outraged, there were people
No,
following the
I'm
story.
not asking to assess the validity of the allegations. I'm asking you the propriety of the legal argument that he's asked us to preclude them because they've been decided already.
Well, I'm sorry, can you repeat that, Your Honor, excuse me?
Is it re judicata?
I would argue no, because of the continuing psychological effect that creates a reasonable fear of imminent harm under those particular circumstances. So there also were clinical notes, records. AT has suffered from significant mental health issues. His legal care was in the proceedings at the time. So including those elements about what's going on with him, and appreciating, Your Honors, that if there was a long time when father wasn't able to see his son, I can understand that that could be a horrible thing. But the reality is he met him where he was. And at that time, he was having significant difficulties with a variety of issues. So the manner in which he came back into his life did, maybe for a different person, but in the totality of the circumstances, caused significant fear of harm. And MC felt that she had to protect her son. But I would also,
Was the letter delivered?
I believe, my understanding,
Clear.
from what I recall, it wasn't super clear from the testimony, Your Honor, but I believe a partner or friend delivered it to the home.
Well, she tried to, and
Tried
we shut
to,
the
yeah,
door on
and
her. Yeah,
my
I don't know
understanding
where
was-
where did the copy of the letter that's in the record come from?
I believe it is that letter. I think, I'm not sure how it,
Did the father supply it or the mother?
into the record? I believe,
Yes,
I believe, I think they both had supplied it, or father had supplied it to, just
So
to
if-
demonstrate.
to follow up, if the mother supplied the letter, that would support an inference that it was delivered. I think
Yes.
that's, okay, so, okay.
And I recall it was an acquaintance who had gone to the home to do that. But as Your Honors had brought up previously, Callahan and other similar cases, Latoya v. Kai, there's a clear legal precedent that if there has been significant abuse in the past, and particularly in Callahan where there's no physical possibility of harm happening, it may still be necessary to extend an order to ensure that the plaintiff feels safe and can continue to feel safe from the effects of that physical harm over time.
Is
And-
there any I mean, I can't remember from the facts of Callahan how long before this application the plaintiff had been harmed, physically assaulted by the defendant. Does it matter? I mean, the core of this, I think, is really obvious. It was 40 years ago. Accepting what she says is true, accepting that there is no res judicata, accepting that this judge, seeing her testify, has the authority to say, I don't care what this other judge said 40 years ago, I'm looking at you, I believe you. Assuming that's okay, and we have to defer to that, and that 40, does it matter that that was 40 years ago? Is it still, does Callahan go that far? Why?
I mean, I would
And
say
why?
that it's distinct here because of the long period of time, but there are also multiple instances on the record of some form of contact, including, I understand it's his right to file in probate court, but the manner in which that's been carried out.
But just to drill down really quickly and summarize, what I saw, two contacts, one by the third party 20 years ago, delivering a letter, which I guess got delivered, and the second going to a court in 2024 and challenging through a legal proceeding the custody. Is there anything else over the last 40 years between those two contacts?
As I recall, Your Honor, there was an incident at the doctor's office once he had found out where the plaintiff was living and where the appellee was living and where the son was receiving treatment. He went in there, demanded to see the records.
Thank you, yeah.
Had a very sort of particular interest in those records, which was also prevalent throughout the other proceedings. I mean, the reason why, and I appreciate that normally bringing that is the vehicle that you have, right, in a circumstance like this, is to file something in probate, but it was very much understood by the appellee here that that was done in bad faith, and it was done to continue enacting control, to continue intimidating.
Sorry, I just want to make sure I understood what you just said. I didn't, it was very much understood by your client that filing the custody guardianship petition was done in bad faith. So
Yes.
Sir, what do you mean by that?
So because of the manner in which the proceedings, were carried out, it was her belief, and she was credited in her testimony, that this was done as an intimidation factor, that it wasn't a genuine desire to reconnect, with a son who is grown up now, who,
I read I know there was an evidentiary hearing where your client testified, and I read that. I can't remember if she testified. Did she testify to that effect? Do you have a record cite for that claim, that she believed that the filing of that guardianship petition was in bad faith?
I don't know that it's said exactly in those words, Your Honor.
Okay.
Well, and did the judge find that that was part of what led to her conclusion of coercive control?
Maybe not clearly from the record, Your Honor.
Did she enumerate any of the reasons why she found coercive control?
She referenced the phone books, the financial control, and just, I don't want to, misstate that she specifically said the litigation, but I do believe, some of the other elements coming back into the doctor's office, and
But you'll agree that that's a factual determination, right?
I'm sorry, Your Honor.
You'll agree that the degree of control vis-a-vis the judicial proceedings is, whether it was coercive or not, is a question of fact.
Yes, Your Honor, I would agree with that.
Yeah, we can't do facts.
No, I understand. I appreciate that. But just briefly to address the other issues raised in this brief, which, whether or not the judge abused her discretion, I can understand, particularly given the set of circumstances that may be worth exploring, but we have a brief that twists and turns and brings up things that are really not relevant. As to the recusal, the judge went on record that she had a professional relationship. Her evidentiary rulings were, and I have put in my brief, I counted them all out, they were more in favor of the defendant at the time. She would consider the rulings afterwards. She would modify sometimes, or she would, indicate, well, I'll just take the first page. She gave everyone an opportunity to be heard. There's no bias reflected at all in the way that she ruled. As a matter of fact, I think she was very patient and generous with everybody and was more, amenable to hearing the full picture, given the fact that this is kind of an unusual case.
Well, it's a small point, but I read the whole transcript. She got frustrated, as any busy district court judge would, that the plaintiff's side took so long. And the first thing she said to the defense when the defense started presenting its case was, "This can't take an hour," like that last one did. Now, I mean, I'm sympathetic. She had a lot to do, I'm sure, but that was not exactly the most even-handed you could possibly be.
I would concede that, Your Honor. But I think when you look at specifically the evidentiary rulings, there's no discrepancy, there's no bias. And specifically going on record, because there's a professional relationship. And my question would be, because MC lives in that area, what is she to do? She has a personal issue and she works in that court. I mean, there's two judges there. She went on record, there's no personal relationship, and that's not what
Let's think about this. She works with the plaintiff professionally in a context where the plaintiff is speaking in court, and the plaintiff's credibility is important. In other words, if the plaintiff isn't translating properly from Spanish parties and witnesses, then that's a real problem for the judge. So if the judge doesn't credit the plaintiff, how is the judge ever going to work with her again as an interpreter? Doesn't that create a pressure for the judge to credit the plaintiff?
I think that any pressure that's created would be outweighed by, the seriousness of taking the judicial conduct rules as a member of the judiciary. I don't see any reason why somebody would want to hurt their career or, not be on the side of justice or not practice impartially and fairly as a judge does, just because she sometimes sees somebody interpret. I think by that logic, every time an attorney that she knows well comes in the court, or, we see each other regularly sometimes, especially district court, you see the same faces, but that doesn't have anything to do with a conflict of interest. There's nothing to gain. There's no money on the line. There's no relatives involved. There's no political promotion. There's, in terms of the classic indicators of conflict, they're not there. And again, she did go on record to make it clear, and defendant failed to raise any objection, any motion practice at the time. So bringing it up now is improper. Just briefly on the evidentiary issues.
We're going to have to, your time is up. We're going to have to
okay.
hold you there. All right,
Never
thank
mind.
you. Thank you both.
Thank you. I rest my brief.
Our next case is 25P860, HOLICK versus Boston Medical Center. Ms. Zucker.
May it please the court, good morning, Justice Sachs, Justice Meade, and Justice Wood. This case comes before the court for de novo review of the grant of summary judgment. The appeal is grounded in a robust factual record that has what few cases do: evidence of substantial expertise on the part of the plaintiff, the appellant here, Dr. HOLICK, in the exact area that brings us to this court.
Can I cut right to a legal question that's been bothering me? What professional standard of practice did Dr. HOLICK reasonably believe was violated here? And where do we find that professional standard of practice in the record appendix?
So the professional standard of practice at issue here is how one handles the question of a genetic disorder that is autosomal dominant, where there is no genetic test.
And where is
there
the most succinct?
There is in the record not only.
I understand where the parties differ, but what is the most succinct statement of what the professional standard of practice is that Dr. HOLICK believes was violated, because this is a statutory phrase, and presumably the legislature used it with the expectation that healthcare providers as potential plaintiffs, healthcare facilities as potential defendants, and courts who have to adjudicate these matters would be able to point to something objective as a professional standard of practice and say, was there a reasonable belief that this was violated or not?
So the professional standard of practice at issue here is the question of taking detailed family histories when there's a suspicion, in this case, of Ehlers-Danlos syndrome, EDS.
Well, that was his standard, right?
Well,
That's what he
it's
thought the
not
practice,
only-
I'm sorry.
I'm sorry.
That's what he thought the practice should be.
It is also grounded in this record on literature, his own and others. What is unique about this case, but perhaps not unique, you see it in medical malpractice cases, is Dr. HOLICK is, by BMC itself, recognized as an expert in EDS. Up to 2015, they said so. Their medical
That seems
office
like a
said
red
so.
herring. I mean, I read that. That seems like a red herring. It seems, it's not a question of being an expert in EDS. As all the pediatricians keep saying over and over again, that's not the point. There's no test for even telling whether a kid has EDS. It seems like you're talking past each other.
Okay, no, I appreciate the point, Justice Wood.
It seems like rhetoric. Nobody disputes that he's a really, really good doctor, and he's done really, really good stuff. The other side keeps pointing that out. They bend over backwards to say, we're not saying he's a bad doctor. You keep going past them with rhetoric. So what's the answer to Justice Sachs's question?
Okay, the answer is, and there is in the record, we've put in genetic textbooks, we've put in the article of Marco Castori, we've put in the articles of Dr. HOLICK, all suggest that absent a genetic test where you have suspicion of EDS, you must take a detailed family history because, as Dean Karen Antman of BU School of Medicine has said, it is textbook that if one parent has EDS hypermobility, that child has a 50% chance of having it. It's math, that is established. If two parents have it, the child has a 75% chance of having it.
We understand
And so
what his position is, that detailed family history should be done under certain circumstances, but what is the evidence that that's a standard? I mean, a standard to me connotes something that is accepted widely in some community, and he could only point to, of his own knowledge, 2 other physicians in the country who share his view of this. So how is it a standard?
I would ask the court to consider the following. The engaging in differential diagnosis before determining non-accidental trauma is well established and standard. Prosecutors across the country understand that. I'm sure this court does. So making sure before you pull that cord that you have done what is correct. EDS, to be sure, is a little studied point. And what I would point the court's attention to are the comments of Dr. Farwell in this regard. Dr. Farwell, and you'll find this at 416, and also in his support for an EDS center at Record Appendix 91 to 94. He writes.
What volume?
He writes.
What volume of the record?
I'm
appendix?
sorry, the Record Appendix 2, 91 to 94, and he writes that when asked about why he supported an EDS center in 2015 under the leadership of Dr. HOLICK, he said at the time, and this goes to the question of established standards with respect to EDS. That is somewhat vexing, and I understand that. At the time, there was no scientific evidence for or against the diagnosis of EDS in kids. And he was asked, did you support his seeking publicity for his views? Did you think it important? He said, absolutely. He said he was encouraging him to voice his views because if he's right, Patients are being misdiagnosed as victims of child abuse when they have a disorder, and that's quite dangerous. I agree with that.
Right, if he's
Dr.
right.
Coleman says he
If he's right.
knows-
So how is it a standard where it's not widely shared? I mean, what does a standard mean
Well,
that could encompass this?
The standard, if you have to sort of back off to a level of generality, and that is why we put the genetic disease textbook in the record. It's why we keep on noting that Dean Antman says it is textbook to look at and to explore family history very distinctly and carefully, precisely because there is no genetic test.
Can I have a more foundational question?
Sure.
Is child abuse a diagnosis? And let me just frame it by saying, I want to be more concrete. Kid comes into ER with a broken arm. They have to treat the broken arm. The patient, the kid is the patient. And I can understand if you were to, the pediatrician were to say, the kid's going to be fine, just bones heal, you don't need any help from us. That is something that you blow the whistle on. That's terrible. But here, what the source of the injury is not who did the injury, an important question, but the person who committed the injury, or if there was a person who committed the injury, is not the core question of treatment for the doctors. Why, in other words, there's two separate questions. How do we treat the injury, and who committed, how did this happen? And why is, it seems that we're conflating those two inquiries.
That they are perhaps not as distinct, and I'm a little bit over my skis because I am now relying on what I have read, but they are not completely distinct. In other words, a child comes in with mottled skin, a history of easy bruisability, other indicia that indicate potential EDS, and recall that Dr. Farwell and Dr. Coleman and Dr. Davidoff have all agreed there really was no wild consensus out there. There was no science that was well established. There was no genetic test, just as is the case for OI, before that genetic test developed. And so the question is, when do you call it non-accidental trauma with all the sequelae for that child and their family? And before you call it non-accidental trauma, which automatically sets off a series of events that BMC, its CEO, its chief medical officer, its chair of medicine, and its division chief of endocrinology have all admitted is potentially dangerous and dangerous care. If you do not forestall, if you don't hesitate before saying non-accidental trauma to try to figure out, do these symptoms look like something else? We need to understand the family history. And the challenge here is we are now focused very much on subsections 1 and 3 of 149, 187. There is also subsection 4. And subsection 4 does not require any notion of established practice. And in this case, where Dr. HOLICK, it is not disputed that he filed reports with public bodies. It is not disputed that he actually filed and complained to the CMO who was charged with peer review, who did nothing. Not about Dr. HOLICK and not about the pediatricians about whom he raised concerns.
Well, it doesn't really
And
matter
so,
if they did nothing, if he was retaliated against for doing something that came within subsection 4.
let me put this differently. He did not address the clinical care. Dr. HOLICK, from the time he started seeing these patients to his last day at BMC, was never the subject of peer review with respect to the quality of the care he actually delivered patients at BMC. Never. That is admitted. It is also admitted that the action they took in 2019, in 2020 to 2021, was variously misleading, in violation of the bylaws, concerning, false. These are their words, not Dr. HOLICK's. And so the breach of contract action, the whistleblower action under subsection B4, I would submit, must lie. I understand that standard of practice is a tough notion. I would submit that if you look at Liu versus Fallon Services, you will be very, very clear that a medical malpractice standard should not be imposed here.
You mentioned the breach of contract. The breach of contract, we're all going to ask the same question. Proof of economic loss or proof of economic harm. What is it? What's the record site for proof of economic harm?
So, two answers to that. First, there is proof of economic harm in the offer letter he received from BU. BU says your annualized salary will be essentially the same, except because it's all coming from your grant money, we have to slash your salary 29%. So his salary at BU is $160. It has gone down since then because, as he anticipated, it is difficult for him to continue to do clinical research. This leads me to my next point.
Is there a record site for that?
Pardon?
Record site? The record site.
Yes, indeed. Hold on.
You can give it to us later in a post-argument letter. I don't want to slow you down.
You can send it in a...
It is RA 60365.
I have an unrelated question about the record.
And the one other point I would make on harm is to adopt the lower court's view of this case would be to eviscerate the age-old notion that expectation damages, consequential damages are available. And I would ask the court to pay careful attention to the case of Lynn Lotke. That case is all about the loss of her career, her ability to do what she does. And in this case, it is precisely thus. So there are economic damages, but equally important, I would argue, perhaps more, is the loss of a clinician's expertise and his love of what he does, which he now
before
cannot
running
do.
out of time, you've asked us to restore the claims that Judge Salinger said in footnote 1 are waived. He's treated as waived because of the violation of the rules. And I had trouble finding your memorandum in support of or in opposition to summary judgment in the record. And generally, under Rule 18, we don't want to see those, but it seems it has independent significance. Because I don't know what those claims are, and then as best I can tell, and you can correct me if I'm wrong, that you make this argument in a footnote.
I have made no arguments in the footnotes.
It's on page
what
38.
What I did
footnote
for
40.
sure.
Excuse me. It's on page 38. It's footnote 42.
No, I understand. What he argues at summary judgment is that because we used a smaller font, what was in the footnotes, he wasn't going to
He
bother.
decided. He didn't argue.
What he decided, thank you, Your Honor. What he decided was that, putting to one side that we've looked at his own practice over the years, and people have often not fully complied with the rules, and he has said nothing about it and ruled in their favor. The footnotes at summary judgment provided additional citations of fact. They were not full arguments lost in the record. He also makes no mention, none, zero, of the joint statement of facts in which all those citations also existed.
Where will we find these in the record? Because it's not in the appendix. And please correct me if I'm wrong.
I'm sorry.
The enumeration he says scores of footnotes, and I don't know where they are.
So the footnotes, as I understand it, were the footnotes in our opposition to the motion for summary judgment.
And is that in the appendix?
Everything that was in the joint record came up to this court.
Where is it in the appendix?
If it's not there, it's not there.
I'm sorry.
Memo in opposition to summary judgment isn't in the appendix.
We can't restore claims that we don't know what they are.
Well, he did not deny claims. He said he wasn't going to look at what was in the footnotes. What was in the footnotes was also in the body of the text and in the joint statement of facts. We had gone through and made sure of that. And there is a more fundamental notion here, which is that this is a de novo review of the factual record, and that, as I understand it at least, is not subject to waiver. Argument is,
Okay.
but that is
All right,
not.
We understand. Thank you.
Thank you.
I'm sorry, Justice Sachs has a question.
I do have one question about the discovery issue and the judge's ruling about the peer review privilege. She said that there wasn't a sufficient showing that the 2021 activities were not in good faith to pierce the privilege. What is the standard of review of a judge's determination that there hasn't been a sufficient threshold showing to pierce the privilege? Is it abuse of discretion? Is it question of law, de novo? Is it a finding of fact?
I
clearly
believe
erroneous?
because this was a question of law, it is de novo. But I believe by either standard, that should be reversed because
Is there any case law? Is there any case? I mean, I thought you would come out and say de novo, but is there any case law supporting that?
I'm sure there must be,
All
but
right.
I
Well,
do
if you
not
can
have it
find
for
some,
you.
we'd like to know about it.
Okay, thank you, Your Honor. And one, if I could.
No, your time is up.
Okay, thank you, Your Honor.
Mr. Persky.
Good morning. May it please the court. Jonathan Persky for the defendants, Boston Medical Center and Evans Medical Foundation. First, let me just address Justice Sachs' most recent question. It is an abuse of discretion standard, and on page 48 of our brief, we cite Simmons versus O'Keefe, that this is the discovery order, and so the standard of review is that the error must be an abuse of discretion, which resulted in prejudicial error.
Generally, we review determinations on discovery issues for abuse of discretion, but an abuse of discretion can encompass an error of law, or a determination that's based on a clearly erroneous factual finding would be an abuse of discretion. So that doesn't really narrow it down. Is there anything more that you can find? And, if you can find something after argument, it would be helpful.
Very well, Your Honor. I'd like to start with Section B4. This is really an issue of first impression before the court, and it's critically important, particularly in light of the amicus brief that we received from the MNA, which urges this court to consider Section B4 to be a catch-all that essentially eviscerates the requirement to show a professional standard of practice, which was the subject of Your Honor's questioning during my colleague's presentation. Section B4 can't be a catch-all because it would essentially read the requirements in B1 and B3 out of the statute.
I would agree with you. It's not a catch-all because it covers allegations of unsafe, dangerous, or potentially dangerous care, whether or not they might be reasonably thought to violate some law, rule, regulation, or professional standard of practice. Whereas 1 and 3 are confined to protesting against or reporting or whatever it might be, those actions that reasonably are thought to violate some objective standard. So there's not necessarily an overlap between the subjects of B1 and B3 on the one hand and B4 on the other. Does that make sense?
I would definitely agree with that, Your Honor.
Okay,
because,
so
yeah.
the next part of the question is, if they are operating on different sort of universes of potential communications or actions by a provider, yeah, sure, there's some overlap. I mean, there may be some actions you're complaining about that violate, that both violate a rule or a reg and also create a, danger to public health, potentially dangerous. But since they do have different coverage, then how would filing a report or complaint to mean disclosing or threatening to disclose make either 4 or 1 and 3 superfluous? I mean, they have different subject matters, so if the verbs about disclosing or threatening to disclose on the one hand mean the same thing as file a report or complaint, what's the problem?
Dr. Hall is contending here that an informal disclosure to management regarding advocacy for changing the standard of care Because remember, the professional standard of practice is the one adopted by BMC pediatricians, which is, as counsel said, a detailed family history, but that our expert says does not include questions related to HEDS, because HEDS in a mother does not lead to fractures or susceptibility of fractures in an infant. So the disclosure that Dr. HOLICK made was unrelated to a violation of professional standard of practice. He did not reasonably believe that this act was in violation of a professional standard of practice. He couldn't reasonably believe, therefore, that the violation poses a risk to public health. So he is trying to avoid the requirements of B1 and B3 by resorting to B4. And so Judge Salinger, in his opinion, focused on the formality of the word filing in terms of filing a report, and I think that's important here. Because if you look at the genesis of B4 and specifically the language that involves participation in a committee or a peer review process or a filing of a report or complaint, in practice, what that means is that if a nurse, and this goes back to the M&A's brief, if a nurse observes something in a procedure that is concerning, so for example, a surgeon working on 2 patients at the same time was the example raised in the amicus brief, that nurse or a doctor or any member of the staff can file an incident report. BMC has a system by which anybody can file an incident report that then gets escalated to a peer review committee, and the peer review process is specifically named in B4. But that is the filing of a report that goes to that committee.
But let's just take the plaintiff's December 23rd of 2016 email to Dr. Davidoff, the one where he says this colleague of his who misdiagnosed something as child abuse is incompetent and that someone should sue her and the BMC. How is that not a report or a complaint about something that Dr. HOLICK believes is unsafe, dangerous, or potentially dangerous care?
Well, I think you have to read that in the context of what had occurred here, because this is a child who Dr. HOLICK advocated on behalf of the parents as an expert witness. And the complaint here was that Dr. Hoffman dared to go up against him in family court and contradict his opinion. And that is what he's complaining to Dr. Davidoff about in this particular email. It's not a complaint of dangerous care.
He's saying that she's incompetent, she misdiagnosed something as child abuse that was quite possibly attributable to HEDS, and that someone should sue her in the BMC. Why is that not a complaint about unsafe, dangerous, or potentially dangerous care?
It took place months after the fact and only after a family court.
Where is there a limitations period that in B4 that says you have to complain within a month or a week or whatever after the dangerous practice in order to be protected by the statute?
Well, I think it doesn't say that, to answer your question directly. This goes back to the formality of filing, because this is something that if a provider observes a potentially dangerous situation within a procedure.
Okay, so say he had started out his email, you know, dear Dr. Davidoff, I would like to file this formal complaint about the other physician, and then he goes on and says everything that he did say. Would that make a difference?
I think you would have to go further and identify why there is unsafe, dangerous, or potentially dangerous care, which I don't think he did in this document.
Well, Dr. Vinci, in his deposition, he talks about the devastating impact of misdiagnosed child abuse. Kate Walsh, in her deposition, is even clearer about the dangers of misdiagnosis of child abuse. So I don't know that the BMC is in a good position to say, oh, this isn't a threat, this isn't dangerous.
I would bring this back to Your Honor's earlier question about can child abuse actually be something that is diagnosed? And what's happened here, in Dr. Hoffman's medical report, she does not diagnose the child with child abuse.
She says in the absence of any better, in the absence of a better explanation, the most likely explanation is child abuse. That's, I hope that's a fair summary of what she said. But it's not so much what she said, it's what he is saying she said. I mean, he says she misdiagnosed something that is attributable to EDS and that she's incompetent. Well, I'm not getting why that isn't a report or complaint about something that it's an allegation And B4 uses the term allegation. It doesn't have to be true of unsafe, dangerous, or potentially dangerous care.
I would say this. First, I would dispute the premise that Dr. Hoffman said anything about child abuse in her report. What she said was that there is no medical explanation for this child's injuries. Okay? And Dr. HOLICK disputes that because of his minority belief, again,
HEDS.
that HEDS causes this. So I think read in context, it is not a B4 report of unsafe or dangerous care. He did not have an objectively reasonable basis to believe that. More to the point here, this email was sent in December of 2016. Okay? The decision by the trustees to restrict Dr. HOLICK's privileges came in February of 2019. That incident is time barred because suit was not brought until June of 2021. There's a 2-year statute of limitations on the healthcare whistleblower claim. So the only cognizable adverse action here is the February 2021 decision by the trustees to revoke Dr. HOLICK's privileges and subsequently a decision by the employer to terminate the employment. So the courts have never found that a gap of more than 4 years between allegedly protected activity and adverse action can constitute a triable issue of fact. And going back to citing Mull versus...
Measure the limitations period from when the allegedly retaliatory action occurred?
I think it's an intervening, you don't have to, right? Because you measure it, no, you're right, Your Honor. You do measure it from when the retaliatory act occurred because that is when the claim accrues under Section 187. So theoretically, a protected activity occurring 4 years before can cause the hospital then to retaliate 4 years later. But under well-established case law, that's way too long of a gap in time for protected activity to have caused any adverse action, particularly in light of all of the intervening events that have occurred since then, okay? So you mentioned the December 2016 email. Even if we concede, and I would disagree, but if we concede that that is before protected activity, he then engaged in advocacy to change the standard of care in emails to the President, Kate Walsh. That's neither before protected activity nor B1 or B3 protected activity. He was then issued a directive to not diagnose or treat children under the age of 13 at Boston Medical Center or BU. He violated that directive. He then promised his supervisors at Boston Medical Center that if he diagnosed a participant in the research center, he would not disclose that diagnosis outside of the institution. He made that explicit promise, and he violated that promise. And in fact, it appears from the record that he had never any intention of keeping that promise to begin with. And that was the reason that Dr. Coleman ultimately took action in the summer of 2020 to initiate the procedure by which his privileges were revoked. So in the unlikely event that the court does consider this before protected activity, and again for the reasons stated, I don't think it should. It's impossible for the court to find a triable issue of fact that the decision to revoke his privileges in 2021 was retaliatory for the protected activity taking place many years prior.
Okay, they did take some intervening action. I mean, there was the 2019 effort?
Right, so, yeah.
You've got kind of a continuing pattern of efforts to limit his privileges and where he could see patients and what kinds of things he could say out of the institution. This wasn't just a single complaint.
I would characterize this as a continuing action because the requirement was imposed in the fall of 2018 that Dr. HOLICK not see children, diagnose or treat children. His privileges were restricted on the same basis, based on that earlier directive. He then, independently of any complaints that he made or advocacy that he participated in, violated that directive, and the record is extremely clear about what he did to submit an expert report that admitted that he rendered a diagnosis on an infant and then recommended a treatment plan for that infant, both in violation of the directives of the supervisor.
Could we talk about the public policy issue a little bit? So Dr. HOLICK bases his claim on 11153H and 112.2D, which prohibit physicians from being contractually prohibited or restricted from testimony to a court or administrative agency. Why doesn't Dr. Coleman's September 10th of 2020 email to the plaintiff where the plaintiff says, can you give me a hint of what I'm accused of so I can prepare for this medical executive committee meeting? And Dr. Coleman lays it all out. He says, you agreed previously, you confirmed your understanding that you weren't to disclose your diagnoses of HEDS to anyone outside the institution, and now you've just done it. You shared your diagnosis with the court as well as with the child, the family, and their lawyer. So why is that not an agreement that BMC is pointing to not testify? And why doesn't attempting to enforce that or upholding it as a ground for discharge violate public policy?
The problem is not the testimony, the problem is the diagnosis itself. And the expert testimony is the evidence that he used that diagnosis outside of the research setting in violation of his promises to the hospital.
Sure, but there's a restriction on him reporting his diagnoses outside of the institution. You would agree with that?
He
says, and he's agreed to it. He says, I won't report any of my diagnoses other than as de-identified in papers, academic papers.
That's correct, because the diagnosis ought to be limited to the research diagnosis within the research setting.
Okay, and then he goes ahead and he discloses his diagnosis to a court, and he's fired because of it. Why is that not firing him because he testified?
It's not firing him because he testified, it's firing him because he disclosed his own diagnosis outside of the research setting. And in fact, if you look at the...
How is that okay under those statutes?
Because there was no agreement with him that he can't testify in court.
No, it doesn't have to be a broad agreement, it seems to me, to violate the statute. I mean, you could have an agreement with a doctor that says you're free to testify about anything you want in court as long as you don't accuse anyone on our staff here at the BMC of malpractice. I mean, that's not consistent with the statute merely because it doesn't preclude all testimony, right?
I would point Your Honor to the email on February 4th, 2019, where Dr. Holick promised not to disclose the diagnosis outside of the institution. And in that email, he himself suggests that his research assistant could actually perform the medical diagnosis, and then he could testify using his research assistant's diagnosis in court, and that was perfectly acceptable to BMC, but he did not do that. He personally diagnosed the infant.
But the claim here is that he agreed that he wouldn't disclose it in court.
The agreement was
among
that
other places,
the agreement that he was not
did.
disclosed it anywhere, and not specifically to testimony.
Okay.
Thank you, Your Honor.
Okay. Thank you. Thank you both. We're going to take a brief recess. Our next case is 25P939, Department in Children and Families versus Father. As you know, it's impounded, so please use designations, initials, whatever you,
Thank you,
just
Your
no
Honor.
names. Thank you. Ms. Foster.
Good morning. I'm Attorney Catherine Foster. I represent the father in this matter. Here, a father was given an impossible choice, stay by his very ill wife's bedside or go to court. It was kind of a Sophie's choice, an impossible decision and a heartbreaking moment.
You know, he could have done a better job of showing the court that he was with his wife, right? All he had to do was like stick his driver's license into the picture with her when she sent that photo of her bracelet, or could have filed something the next day.
I mean, it's easy to look back and say there are things that he could have done differently, but I think, you know, from his perspective, he thought he was doing what he was supposed to do.
Maybe he was, but, you know, if he's trying to balance his responsibilities towards children with his responsibility towards his wife, it seems like he could have done more to show that he was actually there with his wife. I mean, you know, I might not like the tone of some of the things in the transcript either, but doesn't the judge have a right to know whether he's not there because he's actually with his wife, or because he doesn't care about the kids, or because he doesn't want to get arrested because of his open warrants?
Well, to be fair, he was at all the previous hearings. He did visit all the visits. I mean, he might have missed one or two, but he was consistently visiting up until a few days before the trial. He was at the October 2023 trial, and he knew and communicated before the trial began on that first day of trial. And I just don't think it would have occurred to him when he sent the message to his attorney, and his attorney believed that he was in the hospital, said he's in the hospital with his wife. I've, you know, talked with him. She's been in treatment for cancer. And then the court just didn't believe that. So from that perspective, what else could he have done? The court just didn't believe him.
Sent an email back to his attorney. You know, the attorney emails him and says, the judge wants you here, or wants a proof of why you're not. And he sends back an email saying, I declare under the pains and penalties of perjury that I'm here at the hospital with my wife, and I need to be here.
Well, I'm sure if he had more education or a law degry, he could have said something like that. But it's
And the
unclear
judge
even.
keep the evidence open, too, for him to come in.
I believe what she said was she needed to see something, something that indicated the court needs to actually see that she's in the hospital. And, you know, he did say he had poor cell service. He, you know, used email on his phone to communicate with his attorney, but it's unclear how much could get in or out, and so how much communication could actually happen during that time. So when he took the picture, it showed that she was in the hospital. It showed name, date of birth, so it's her. It showed admission date, the 20th. I mean, the judge didn't accept it, but that doesn't mean that's not where they were, and in fact, it shows the judge was, you know, the evidence shows the judge was incorrect.
Can I ask, I guess it's sort of in the category of harmless error, although I don't know if that exists in DCF termination, but that I understand the judge clearly made a finding that she did not believe the father and used that against him. I get that. But given it seems that the core of the judge's concern here was elsewhere, that the core was a series of neglectful behavior that was heartbreaking, and he was doing the best he could. But nevertheless, medical neglect, dental neglect, educational neglect seems to be the core of the judge's concern. If that's a fair characterization, which you can challenge, does that render this finding about him not being present on that day because he was with his wife harmless error?
No, Your Honor, because 99% of the information was about mother, and for instance, severe medical neglect. It was an abuse of discretion for the court to find the children suffered severe medical neglect when DCF was working with the family, saw the children every month, spoke with the pediatricians. Despite the fact that they were behind on their annual physicals and they had to get caught up with vaccinations, they did get the physicals, they did get the vaccinations, and the pediatricians didn't have any concern in that time. So it doesn't make sense for the judge to go back and substitute her impression for DCF's percipient observation, where DCF was saying, the children are doing well. They were behind, and now they're caught up. The pediatrician didn't have any concerns. So,
All right, just to drill down on that factual point to make sure I'm remembering correctly. They got caught up before the removal in October of 2022. Is that what you're saying?
Yeah, they were caught up in September, early September. They were, I believe, maybe September 8th. They were removed on September 30th.
Okay.
And they weren't removed for any kind of medical neglect.
Right, they were removed because they found the
Because
eight-month-old.
the parents lied
Right,
about
lied
the baby.
eight-month-old. Right, but your point is that they did actually, DCF verified that the parents got the kids caught up on medical issues, treatment, before they were removed. That's your point.
Correct.
Yes, okay,
Correct.
okay.
And multiple times, actually. And some of the evidence, that's the other thing, is that most of the evidence about father, if the judge had had the opportunity to weigh his credibility, which he didn't because father never testified, most of the evidence about him is positive. I mean, there's evidence in 2020 when child number 3 was born that it was right after they moved into the shelter because they'd been evicted. He was the one who made, despite the fact that they didn't have a phone, he used the shelter's phone to enroll them in state benefits, to re-enroll them with the pediatrician. He stayed in the hospital with the baby, set an alarm so she ate enough so she could be discharged. She gained enough weight. After he was home, his wife suffered that serious preeclampsia medical crisis, and he was at home with the children for weeks.
So I didn't have enough time to try and reconcile this, but the judge quite clearly repeatedly found that they failed to get adequate health insurance for the kids. And notwithstanding mother's immigration status, these 4 are all American citizens, so he can get mass health for these 4 kids. And so the judge was conveying a finding that the parents, were alleging they couldn't get treatment. Part of the delay was because they didn't have health insurance. And in fact, they could get health insurance. And I know you were broadly, what you were just saying broadly, and you said this in your brief, that dad did make that all happen. Is there a delay? I didn't get farther than that. These seem to be contradictory statements. I mean, yours versus the judge. What am I missing? Who's right?
About the medical neglect?
Was there a delay in getting medical insurance? And whose fault was that?
Yeah. It seems what happened, and it isn't drilled down to really understand when father was employed, because at times when he was employed, he would put the family on his insurance. There's no evidence about, every employer is different. So it seems like probably what happened is he'd be employed, they would get kicked off Mass Health, and then they wouldn't have insurance. And then DCF would find out they were behind, and then father would be unemployed, and they'd get back on Mass Health. It just sounds like it was kind of chaotic that way.
All right,
because
moving to dental neglect, the statements, the factual findings are very emphatic. The children never went to a dentist, teeth were rotting. So do you dispute that?
That I don't dispute. That happened, and
Okay.
they should have taken the kids to the dentist.
All right. And then educational neglect. I was a little confused about that, but I think that the older of the 4 were supposed to be in school. What's the educational neglect specifically?
I mean, there. To
Your
the
view
extent
is
that there was educational neglect, I think that was also an abuse of discretion.
Okay.
Because there were.
Right, okay, but so then the condition of the apartment, I checked the case law, the Commonwealth, DCF is right, I read the cited case, the judge is absolutely allowed to consider, it's factually analogous. And here, I looked at the pictures, something happened between 2017 where they had they were doing well. In 2019, they're on the edge of eviction. We can't speculate, but something bad happened. And that house is they are clearly struggling mightily. And it's fair to say that it's dangerous. It's filthy. It's not just dad's a bad housekeeper. It's actually getting dangerous. And what do you say about that?
That DCF never removed for that reason. DCF doesn't remove for that reason. That most of the notes, including in 2020 when mother went into the hospital for an obstetrical complication, the DCF social worker says it's unsanitary but livable, and leaves all the children with father to take care of them. And I think the social worker's right. DCF doesn't remove for bad housekeeping. And
They may not remove for that alone, but are they stopped from raising it as one ground to support an unfitness finding if they, sort of a constellation of factors develops that causes them to remove at a later point?
As part of a constellation of factors, I'm sure the court can consider it. But in this case, there just isn't enough evidence of father's unfitness. And all of these situations that happened with mother. And he did have, it seems, a problematic relationship with mother, but mother's gone. And he, throughout the case, was more stable. He was the one who DCF could communicate with. He told the truth. I felt that the judge's finding that father knowingly concealed mother's substance misuse was especially an abuse of discretion because the court issued that finding in response to DCF asking him to tell them the absolute truth about whether mom had ingested any drugs before she went into the hospital. And he was honest and forthright and gave very damning information that he actually purchased drugs for mother before she went into the hospital. And so it's confusing how that was concealing.
Can I ask a question about the credibility? You say one of your argument headings, I think, is essentially the judge relied too heavily on the father's lack of credibility. But then I think on the next page you say, well, judge made a lot of credibility findings, only three of which pertain to the father, and the majority of them pertain to the mother. So I couldn't quite put those two together. If she only made three adverse credibility findings for the father, then how did she rely on his lack of credibility too heavily?
I think really what she did was impute mother's lack of credibility to kind of cover both of them. Because if you look at the findings regarding father, I mean, one of them is she found that he was, I think, dishonest because he said his sister was probably filing 51As in 2019. That really has not only nothing to do with his parenting, but to have to go that far back in the record about a sibling disagreement that has been well resolved. He listed his sister as a resource at the time of trial. To me, it's just evidence of how little evidence there was about father's unfitness, that the court had to go 5 years back from the time of trial to find that one small thing.
Can I go back to medical neglect for 1 second? You say that the kids were caught up, the 3 children were caught up as of the time of removal. But what about the 4th child who was born 7 or 8 months before removal, who had, existence had been concealed, had never gotten prenatal care, postnatal care, any, probably not vaccinations or any of the other things people usually do. So doesn't that suggest that even if everyone was caught up by the time that child was born, the parents hadn't really learned, including father, hadn't really learned you need to keep on top of the kid's medical care?
I mean, that was a poor choice. They shouldn't have hidden the 4th baby, and that is arguably the only evidence of neglect in the record by the parents towards the children. And I guess all I can say to that is that is another thing that happened with mother, and mother's not here. And in general, father was able to be very honest and forthright with the department, to communicate with the department, when he'd signed the kids up for state benefits, et cetera. And I see my time is coming to a close. So on father's behalf, I would just ask that you remand for the trial that he didn't have and give him the chance to be heard and for his credibility to be weighed. Thank you.
Thank you. Ms. Bertino.
Hello, Caitlin Bertino on behalf of the department. In this case, father's unfitness is overwhelming. It resulted in the 4 subject children suffering medical neglect and dental neglect. They had to live in unsanitary housing conditions that were at times dangerous. The children were unvaccinated, behind on their medical care. There is a finding, I don't have the record appendix site, but it's on the finding page 23, the last paragraph, that 2 of the children, including, so children, I think it's the numbering of them, so I don't say their names, but I think it's children 2 and child 4 were not up to date on their medical exams. They were behind on their immunizations. And then the older child, who was initially a part of this petition, but was reunited with his birth father, he was also behind when he came into care on his medical care. Additionally, the older children of the 4 that are still on the case, they were 5 and 6 years old when they came into care, and they were still in pull-ups. A couple of the children were developmentally behind. 2 of them were born substance exposed, and the youngest child was malnourished and underweight. He has to be checked by a doctor every 6 months because of his weight. So the evidence of the effect on the children here is overwhelming.
I noticed that in your list you didn't include educational neglect. Are you not relying on that?
So the educational neglect, I think, is more focused on the older children who were initially a part of the case but aged out. At the time, I know the department regularly wanted the younger children to be in daycare and wanted to be involved in early education, early intervention, and there was some attempts to sign them up by the parents for the early intervention. I don't have the direct site for that, but they were not able to follow through. So yes, also educational neglect for early intervention.
Is this the older children who aged out?
No, the younger children, I think it was child 1 and 2 were supposed to be, or 1 or 2 were supposed to be in early intervention, I believe, and had, or maybe it was 3, I'm sorry, I get the numbers confused. And the department, I can find the place for you and submit it in a letter if you'd like. We're supposed to be engaged in early intervention. But I think the bigger picture for educational neglect is the older children.
And what is that? By the older children, you mean the older 2 of the 4 that are at issue here?
There's actually 3 older children that aren't on this petition.
Okay, so is the educational neglect as to them or as to the older of the 2 children who are on this petition?
Oh, I see what you're saying. I believe that the educational neglect is for the older children who are not on this petition.
So then why is it relevant here? I mean, and why did she spend so much time on it? The judge spend time on it in the decision if it doesn't apply to any of the 4 subject children?
I think as it's part of the bigger picture, the parents, their parenting of all of the children can be considered and their past actions can be considered. These children were very young, and based on how they've parented their older children, there was no evidence that they would continue to have these younger children engaged and attending school once they were of age.
So there was time spent on, or attention spent on, father's refusal to cooperate with mental health evaluations and substance abuse evaluations. Mm-hmm. At least on mental health, is that I didn't see any evidence of fathers suffering from mental health problems, other than, I guess, inferences were asked, but we weren't even asked to draw inferences from the record. But so, can you speak to that? First of all, mental health.
Definitely. So the department was concerned because of the effect on the children. Father was unable to maintain housing. The children were being neglected, and without an evaluation, without engagement in mental health services, the department couldn't assess what father's mental health issues were. Also, the department wanted the father to engage in substance abuse evaluation as to his partner. Mother has a clear history of substance misuse, and the department wanted father to engage in therapy to learn how her behavior was affecting the children and how his enabling her behavior was affecting the children.
Oh, I see. So it's him enabling mother's drug-seeking, drug misuse.
I think that that's part of it, yes.
Okay.
I'm unclear on the mental health. You know, I understand that if he wouldn't sign releases or go get evaluated, then the DCF couldn't come to a proper conclusion. But what's the evidence that he needs to get evaluated?
I think the evidence is that someone without, the fact that the children were being neglected, and there's clearly something going on that's leading to this lack of care on behalf of the children, and the department was trying to figure out what that issue is in order to help father maintain these, or become a fit parent.
Can one conclude from the lack of evidence and his refusal to go get an evaluation or to stay in therapy, that he in fact had a mental health issue?
I think you can conclude that. You can infer that here. He refused to cooperate with the department. There were many times throughout, this case has been going on for 6 years since the department initially started working with the family. There were many times where the department tried to assist the family by providing parental assistance, house cleaning assistance, lots of supports that the parents refused. So I think that
if you don't accept DCF's help, then you must have a mental health problem?
No, I think it's looking at the big picture of all of the different ways that father was interacting with the department and interacting with his children, and more importantly, the results of the children's neglect and father refusing to seek help for that.
Well, right, but I mean, I'm struggling to understand. It seems like a lot of this must be a product of poverty. And so I'm trying to distinguish between you must have a mental health problem and you must have a poverty problem. And and then the next step to sort of work in what Justice Sachs was just saying, and if you don't get the mental health evaluation we think you need, then that will be held against you and your on the question of your fitness, when it could be your poverty. And I mean, I recognize this is all speculative, we don't know, but how is that okay?
Well, I think that there is clearly a poverty issue here, and the department attempted to help alleviate some of those issues by offering different services, by offering assistance, financial assistance, free house cleaning, things like that. So I think the refusing the assistance on top of the children being neglected, and it's not just poverty. The parents here hid a child for 8 months, never got him medical assistance, never got him a birth certificate, and there are lots of, that's just one thing in the many factors in this case.
Okay. Refusing assistance, sorry, this factual record is big, and I know you're dealing with a lot too. They did accept a lot of assistance. Most importantly, most obviously, when the house was foreclosed on, they moved relatively quickly to get a shelter apartment. And they also worked with DCF, I think, to get health insurance. In other words, it's not really fair to say that the father wasn't working with DCF, but more accurate, I guess, to say he didn't do everything they wanted him to do. Is that fair?
Well, I would say that he worked with them sometimes. Initially, he refused to admit that the first home that they lived in, that they were going to be evicted. They could have gotten help sooner if they had discussed it with the department. Also, after he stipulated to his unfitness, father refused home visits with the department. He attempted to do therapy, but he was released from services for not engaging with the therapy, and he didn't do any of the other action plans that he had been asked. He had already stipulated that he was unfit at the October 2023 trial, and at the review and redetermination trial that he didn't appear for, he hadn't made any progress. I see that's the end of my time. If you have any other questions, I'll rest on my brief.
Seeing none, thank you. Mr. Thierman.
Good morning, Your Honors. My name is Jeremy Thierman, and I represent the children on this case. There are 4 children that remain on the petition at this time. The children are all housed together in a pre-adoptive home. My presentation, I'm going to focus on the best interests of the children. There were some issues raised by father as to whether or not his parental rights should be terminated and whether it's in the best interest of the children, to be released be freed for adoption. It's the children's position that the evidence supports the judge's finding that the best interest is served by remaining in the pre-adoptive home and terminating father's rights. Father does have visitation according to the trial court order, which was specifically requested, and I think the record supports the judge's determination that there's a bonded relationship there and that it's in the children's best interest to have that visitation.
Can I ask a specific question about the impact on the children if there were to be reunification? The judge relied on, she went through the statutory factors, and one of the ones that she said was applicable here was factor 7, which basically says the forced removal of the child from the caretaker, meaning the foster placement, would likely cause serious psychological harm to the child, and the parent lacks the capacity to meet the special needs of the child upon removal. Do you agree that that's applicable here?
I do, Your Honor.
That the removal would cause serious psychological harm to the children, and that the father lacks the capacity to deal with that harm?
Yes, Your Honor, I do agree with that finding by the trial court, and I think it's supported in the record. With respect to how that factor is applied in a circumstance such as this, where that factor is one of several factors, the level to which the case law orders the trial court to make its findings is a little bit nuanced. Because it's not the primary reason and it's not the decisive reason.
You don't have to make special findings about it or have an expert testify about the harm.
Yeah, the language that I think I quoted and I really think is helpful is that the trial court doesn't have to make these granular types of findings, in that they are able to infer where there is a bond between the current caretaker and the children that removal would result in some harm. With respect to the children's special needs, the record does cite to the children's special needs, and these were things that were not being addressed while the children were in care.
Is there a difference between special needs and specialized needs? I sometimes think that the term special needs is a little bit of a euphemism, and that specialized needs might mean something else.
Yeah, and I think that's
particularized. I mean, every child has particularized needs, don't they?
Exactly, and I think that that's a really difficult question for the fact finder to struggle with. If you apply kind of the common definition, we think of special needs as a child who maybe needs an IEP or is medically complex, something of that nature where there's a lot of interventions needed for this child. These children don't necessarily reach such a high level as that, but it is significant that the judge found that as to each children, and I know I went through it on page 20.
None of them seems to have behavioral issues.
I'm sorry?
None of them seems to have behavioral issues that I saw.
No, but there was, I'm sorry, I don't want to talk.
Or learning disabilities. I mean, there was, the youngest was being evaluated for an IEP, but we don't know the result of that.
But we do know that the oldest child still on the petition was academically behind, that she struggled with her writing ability. We know that the next child had been diagnosed with ADHD, and we know that the third, there's the youngest little boy, and then there's the girl above him had an eye issue, and she was being followed for that. I don't think that these are knockdown special needs issues, but they are issues and needs that were not being addressed. And I see my time is up. I think that's how those apply, and we'd ask that you uphold the trial.
Thank you. Thank you all. We'll take it under consideration. Our last case is 25P946, DUC HOANG VO versus Cianturo. Mr. Sales.
Good morning. I'm Jonathan Sales. I'm here on behalf of the appellants. The issues that we're raising in this case are twofold. That we respectfully submit that the attorneys were not did not have the authority to settle the case. And secondly, that there were material terms that were left out of the initial issues, and so there was no settlement offer.
The attorneys testified in a hearing, and an evidentiary hearing, and they testified to the contrary, and the judge credited their testimony. Your client testified to the opposite, and the judge explicitly found his testimony not credible.
Right.
What is left?
First thing is that I would say that the review of this is de novo. And second of all, there were inconsistencies on both sides. So the lawyers, and I'll get to the lawyers' testimony, but Judge Deakin found that that a motion to enforce a settlement is treated as a motion for summary judgment, and so it should be reviewed de novo, I would respectfully submit, and that in Gibney versus Hosack, 493 Mass. 767, 2024, the statement is, our review of a decision on a motion for summary judgment is de novo. So under the circumstances, the court has de novo. I would respectfully submit the court has de novo authority to look at the credibility. And if we look at page 8 of the brief, there is a number of things that Jordan Shapiro said that undermine the fact that there was an agreement. For example, at the top, Jordan Shapiro said, you know, you could put whatever spin you want on the word choice. We only agreed to certain basics of a settlement on Sunday night.
That's after the date of the settlement.
Oh.
And they're talking, according to your opponent, about something completely different.
Well, I wouldn't say it was completely different, because I would respectfully submit that it had to do with the conversation on September 10th, and that's what he's referring to. And then secondly, in his testimony, Attorney Shapiro, and of course I would respectfully submit this, that the proposed settlement that was received afterwards was totally new. I was shocked when I saw it, and I was surprised. If I had known it was coming, I would have probably stayed late and tell you to your face that we weren't accepting those changes.
Right, and that's all after the settlement had been approved. It's after his associate, who, I'm summarizing his associate's testimony under oath before the judge. Yes, I went over the new terms with our client, and I'm sure that our client approved each of these terms, and the judge found that credible. And so the testimony you just gave me is what his boss learns after the fact, after the settlement has already been approved and filed in court.
True, but the next step is that the circumstances, and there's plenty of testimony from the client and from Attorney Shapiro, that whatever happened, and let me read one of the authorities to you. Just give me 1 minute, okay? Let me get this out. The authority. That in Cagno versus MBTA at 101 Mass App Court, 115-2022, that the court specifically states that just 1 second more and I'll read that to you.
Whatever you're going to say, it's an unpublished opinion, right?
That when the court undertakes to bind his client by an agreement to compromise his client's substantial rights, the opposing party must ascertain at his peril whether the attorney has authority to make the settlement. And there's substantial, and I would ask you to review it de novo, there's substantial evidence in the record that the client and Mr. Shapiro didn't authorize that. And even though Shapiro's testimony is afterwards, he's the one that originally was negotiating the settlement. And there was substantial evidence in the record as well that Mr. Ciantori didn't authorize things like mortgages on the property, the $50,000 penalty, and
let's assume that we, what I'm struggling with, let's accept for the sake of argument that we have the authority to review this de novo, which I don't think we do, the trial judge's credibility determinations. The associate very clearly testified that he identified each of these additional terms and that Mr. Ciantori accepted each of these additional terms. And he then and only then did the associate report to the other side that we have an agreement. Assuming we have the power to review this de novo, on what basis should we, where the testimony is clear as day?
No, the testimony, I would respectfully submit that the testimony is not clear because, and I would respectfully submit this, that Mr. Ciantori testified that he didn't agree to that, and there's another person who was present, Roy Lloyd, who submitted an affidavit to the court.
Right, sorry, that's an affidavit, and that's all hearsay. He could have testified at the evidentiary. You weren't precluded from calling Mr. Lloyd as a witness at the evidentiary hearing, right?
Right.
So why would we be, under what theory could we consider his affidavit?
Well, the affidavit, the other side could have also called them, and so.
But you're trying to get us to consider de novo this finding, and so you want us to, you want to focus, produce evidence. It's your burden to produce this evidence.
Right.
And so it's not that they failed to call Mr. Lloyd. Why would they call Mr. Lloyd to corroborate your client?
It was significant to attempt to undermine him. You know, his affidavit was very clear that the testimony that was provided by Mr. Sianturi was accurate, and that he didn't agree to the $50,000 penalty. They didn't agree specifically to any mortgages on the property. They didn't agree to any liens on his home.
I have to ask a question, because I need to give you a chance to answer it, and I'm sorry how this is going to land. But my question is, why is this appeal not frivolous? On the one hand, it's a direct appeal from the settlement. So usually settlement, you have an appeal as of right. Okay. Is there a limitation on an appeal as of right for frivolous matters where you're asking us to do things we think we don't have authority to do, and it's a pure credibility determination? Why is this not a frivolous appeal?
Because of the testimony of Attorney Shapiro, the testimony of Mr. Sianturi, and the affidavit. It's not frivolous.
Okay, so your response is factual. I guess, is there a legal standard that you want to focus me on?
Sure.
For a frivolous appeal?
I'm happy.
Okay.
Well, not for frivolous, but there's a legal standards that are in the brief that show that, for example, missing material terms. Okay, Nelson versus Robello. Broker's commission was not agreed to. That's 26 MAP 270, 1988. Rosenfeld versus Trust, 290 Mass 210. The parties didn't agree to who pays the water and who pays the storefront. These were missing elements. Bloomingdale versus Imbracia, 25 Mass Appellate Court, 144, 1987. There was a purchase of real estate. They didn't agree on the rent roll and rental fees. And as a result, those weren't considered ministerial. Contos versus Sullivan, 250 Mass, 376, and the failure, they failed to articulate mortgages on the property. And the failure to articulate mortgages on the property are specifically a basis in Consos versus Sullivan to overturn an agreement. And the fact that Mr. Sianturi would not have, and he testified to this repeatedly, he would not have agreed to putting any liens on his private home. And the fact that they did not, the fact that he could suggest what mortgages there were, that's not under Consos versus Sullivan. That's not sufficient to substantiate those mortgages. So those mortgages were not agreed to as a matter of law. And these are between pages in the brief. Give me 1 second, I'll give you my brief pages. These are between 43 and 48 of 49 of our brief. I appreciate your questions, okay? They're very good questions. But I would respectfully submit that under the circumstances, that Shapiro's testimony and Mr. Sianturi's testimony undermine any suggestion that there was a full agreement. And I put a number of cases in there and analogized them. And second of all, the fact that, I'll wrap this up right now, that Attorney Shapiro went home and he was the lead attorney, and that the other attorney, LeBlanc, indicated that he did not read the entire.
Okay, we're gonna have to leave it there, Mr. Sales.
And
Thank
then
you.
second of all,
Mr. Sales, your time is up.
oh yeah, the fact that he was in New Hampshire.
Your time is up,
listening
Mr.
to
Sales.
someone undermines his ability.
Mr. Hudak.
Thank you very much. And I would rest on the brief.
Good afternoon, Your Honors. May it please the Court, my name is William Hudak. I represent the appellees, the Vos, who are also the plaintiffs in the underlying case. Justice Wood, I think you hit it right on the head. I think I made this a central portion of my brief. This is a frivolous appeal. It's a very simple timeline of facts that are laid out very clearly in the testimony of both Shapiro, Attorney Shapiro, and Attorney LeBlanc. That testimony was clear and unequivocal that during the applicable short time frame from September 8th to September 10th, we engaged in settlement discussions because we had a full week-long trial scheduled for September 11th. So the timeline was very clear. When this motion to enforce the settlement occurred, there also were a lot of other emails that occurred between that time and Attorney Shapiro and LeBlanc being terminated and Attorneys LeBlanc and Birch being picked up 3 or 4 months later when we finally were ready to get to it. If you look at the simple set of facts, and here's the simplicity of the case, the settlement agreement was in an email that I sent and drafted on September 10th at 9:07. That was very detailed, point by point, that said the defendant will pay $200,000. He will pay in 60 days. He will pay 100 of it. In 6 months, he will pay the other 100. So the amount and the timing was clear. But because he wanted extra time, there were some stipulations to make sure he kept his agreement. Remember, this was an underlying fraud case where there were very serious problems that cost my clients hundreds of thousands of dollars. Their single damages number was $250,000, with serious possibilities of triple damages and legal fees, which could have made it a $700,000 to $1 million case. We did not trust him, so if he wanted more time to pay, that was fine. So the settlement agreement stipulated, if you miss a payment, it's the $250,000 that my clients want, because they've been waiting 4 years. They were entitled to 50% interest anyway, which was part of the whole thing. That's why the $50,000 figure was taken. And they would sign a note and a promissory note secured by mortgages that would guarantee the payment of that.
And all of that was in the email.
All of that's in the email agreement. There was nothing left open except we gave them the opportunity to say which of your many properties, he had about $10 million worth of properties, show me which one you want us to put the mortgage on, your choice. And if you can't, and just show me it's got $400,000 in equity. I'll just hold that in escrow. It won't harm you. If you make your payments, tear them up, goes away. That's the agreement. Make your choice. If you can't make a choice, it'll be on your home. Okay? Those were very clearly written in the email at 9:07. That was the fundamental part of the agreement. Now, once that was done, the evidence in the record shows that I had been dealing with Attorney Shapiro before this time, but he had gone home for the night, and he had left it to Attorney Blank to finish up. He had suggested a lot of those various provisions. He had suggested, we'll give you security, we'll give you a personal guarantee, We want to keep Mr. Santori out of it and just put it on one of his entities, which I didn't care as long as we had, as it says in the agreement. The only thing that Attorney Shapiro was not aware when he went home for the night was I hadn't spoken to my client about whether that was agreeable. And when I finally came back with the 907 agreement, which was to both Shapiro and LeBlanc, it included the $50,000 and a $400,000 mortgage. Those were very clearly in there. That was surprising to Mr. Shapiro because he had not heard it, but he and Attorney LeBlanc talked about it, and it was left, and it's clear in the record, that Attorney LeBlanc would call the client, make sure he's aware of all that, get his agreement. And if he agreed to it, he would do it. And that's what happened. He then called...
Blank testified to that.
That's the way he testified.
Right.
And then he also, in the same testimony, said, I went through the whole email point by point by point, not only read it to him, but discussed every single one of those. So Justice Frazier, who's now the trial judge listening to the evidence, is now seeing that. All of that record is clearly identified, convincingly, overwhelmingly, because it's all backed up by emails confirming each one of those steps all along the way. The other thing that was clear is that Mr. Santori, during that day, for at least 3 to 5 hours, depending on which testimony, was in the office with the attorneys, getting ready for trial, talking about every single one of these issues. And a lot of those issues could only come from Mr. Santori. He's the one who knew how much time he needed to come up with the money. He was going to propose to sell a piece of property, which in fact he did sell within the first 90 days, had all the money for the $200,000, but just decided he didn't want to pay. He just broke the whole agreement. So there are no issues at all for this court to review. Justice Frazier has the ability to hear all that evidence. But what was shocking, which makes this really important for this court to understand, is that Mr. Santori was sitting in the courtroom during all that testimony. When I put him on the stand and just asked him simple questions, like you heard, he denied ever, not one time, ever having any conversation with any attorney about settlement at all. That was arguably perjurious, but at least disingenuous.
That's when Judge Frazier
That's when
pulled
Judge
out the
Frazier
email.
himself picked up and said, let me ask him some questions, confronted him with his own emails admitting he had agreed to the $200,000,
Right.
admitting they had discussed it, emails and all kinds of other, that's all
Right,
clear in the
so
record.
Judge, to
There
sort of
is
cut
no-
through this, Judge Frazier found, it's very clear in the record, the court does not credit the testimony of Jay Cianturi that he did not understand the terms of the settlement agreement and did not authorize Attorney Shapiro and LeBlanc to enter into the settlement agreement. Do you, and I understand why, there's ample evidence why, including what you just referenced. Do you agree with your opponent that there's any basis to conclude that we have the ability to de novo review those credibility determinations?
Absolutely not. I think you have to review it on the clearly erroneous standard. I don't think there's a question about that. The only de novo issue that they try to raise is determining whether the terms of the settlement agreement were sufficiently complete and definite.
Right.
Is a de novo review. Judge Deakin found in 2024 that they were applying the proper standard. Right. Judge Frazier, during the hearing, applied the same standard, found it again, and so there is nothing. So the question is there anything missing?
Right.
They're trying to extrapolate because Attorney Shapiro had not heard about the $50,000 and the $400,000 mortgage,
Right.
which he did before this was finalized an hour later. They're saying, well, that was something we tried to bring up later. It wasn't. It's in the email of 907, which is the agreement that they were fully authorized to settle, which was discussed by Attorney LeBlanc with Mr. Santori, and all of it was fully agreed to in accordance with that. So there really is nothing for this court to do at all, which is why, to the point, I think it's a frivolous appeal. I think my clients are entitled to attorney's fees for 2 reasons. One, it's part of the agreement. The settlement agreement clearly says if he breaches the agreement, then the $250,000 kicks in, and we're entitled to prejudgment interest, which we still don't have it, and we're entitled to legal fees and costs of collection. That's the agreement. In fact, Judge Frazier, in his order of January 21st of 2025, after the hearing, found that he was in breach of the agreement and expressly added legal fees and added the prejudgment interest and added the $50,000. Those were all certainly based, again, on credibility of the evidence. And so we're entitled to it for that reason, but I think we're also entitled to it because under the standard of this court, there's really no reasonable expectation because there's nothing to appeal. It's a client that wants to have someone else take a look, and what they're asking you to do is to take the place of Judge Frazier and decide on papers that Judge Frazier should have believed Mr. Santuri's side of the story, even though he contradicted himself and Judge Frazier found he was uncredible, and in fact may have perjured himself because he himself pointed out that he wrote emails contrary to his testimony, and all the other things that we say. So if you have any questions beyond that.
I have one question. Your brief makes a point of asking us to order post-judgment interest at 12% from the date of the judgment. Isn't that automatic? Is there some reason that we would have to do that specifically?
Well, frankly, I don't do too many appeals.
If we affirmed.
Yeah, if you were to affirm the judgment, I would think the court would be automatic. I just want it to be highlighted that in the settlement agreement, it does say that we're entitled to 12% interest. The court below only ordered the prejudgment interest up until the date of the original finding, which was sometime, I think, April 4th. So from April 4th to now, it's been another year and whatever. I don't want to ignore the fact that my client's entitled to that interest until this case is finalized, because I'm not going to be able to get rid of execution until it's affirmed or so forth. I want to make sure that the interest is included, and I want to have the opportunity to add the legal fees to bring them up to date. If that means remanding it down to the Superior Court for those determinations to be sure, or whether you do it, frankly, my expectation was that this court would allow the legal fees, but I wanted to make sure the interest is also included, because it's part of the agreement.
Thank you. Thank you both. That'll conclude today's proceedings. I'd like to thank my panel,
Thank you.
our court staff, the clerk's office, our law clerks, and court officers, and our excellent timekeeper, and we'll stand in recess.